stop 10 to 4, so.
Okay.
So, good afternoon, ladies and gentlemen. Given that we're running a little bit behind the schedule, I take the liberty to start this session on GDPR. My name is Wojciech Loupek, and I'm the partner with Bird & Bird based here in Prague. So let me also welcome you at my home turf, so to say. I hope you'll like it. And as I said, the topic of this panel is GDPR, or if you want, GDPR and privacy in general. So a very exciting topic that I don't know how many times I've heard the abbreviation GDPR this year. It's probably a very large number. There's been lots of myths around it, lots of hysteria before the 25th of May. So we thought we would look at how the gaming market in particular has addressed the issue and how it's proceeding with the implementation of the GDPR and privacy issues around the world. First of all, let me introduce you the panelists on this panel, and before I start, actually, let me also excuse Alexia Kukulis, who those who have heard the program, you've probably noticed that she's missing. She had to cancel her trip to Prague at the very last moment, and sends greetings to you all. Of course, we're not getting high marks for diversity on this panel as a result, but there you go. So from the far end sits Simon Brown. Simon is Senior Privacy Manager at Paysafe Group, one of the world's biggest online payment companies or operators. And Simon's been working in the field of data protection and privacy for nearly 20 years in lots of industries and areas, including law enforcement, telecoms, technology, financial services. Next to him is Jindřich Kalíšek, who has agreed on a very short notice, in fact yesterday afternoon, to jump in and take Alexia's seat on the panel. Jindřich is the data privacy officer with KKCG Group, which is basically the owner of the Sazka Group, which Sazka obviously not only the biggest lottery company in the Czech Republic, but also very much involved in the gaming industry, also in other countries, including Greece, Italy, Austria, and others, and also kind sponsor of our gala dinner tonight. Next to him, Alan Houston from Ireland, partner at McCann Fitzgerald. A very accomplished and experienced gambling lawyer who has also experience from in-house. I understand Alan worked at Paddy Power Betfair before joining McCann Fitzgerald. So he will present views from Ireland and from across the pond. And closest to my right is Sean McGuinness, who's also a long-standing IMGL member, I suppose, so probably no need to introduce Sean to you too much, but a very experienced commercial gambling lawyer who's based in Nevada in the States. So that's for the introduction of the panel and who's going to be speaking to you about this wonderful topic of GDPR. Of course, we'll like to make the discussion as lively as possible, so we'll open the floor to your questions as soon as we can. But first of all, let me just do the first round around the table and ask the ask the panelists about how their life has been coming up to the 25th of May and how it's changed after that, and generally what their observations have been with respect to GDPR implementation in their respective countries, and what sort of general observations they have made, and we can then jump into sort of more specific issues. So if I may start at the with Simon at the end of the table.
I don't know. Is that on? Does this one work? Yeah. Great. So leading up to May, I think generally focus was on ensuring that our programme of work was properly organised and that we'd covered off all the things that needed to be covered off. I mean, I think what I would say is that for people who've been around in privacy for a long time, such as myself, GDPR hasn't massively introduced some really new things. A lot of them are enhancements. The kind of big ticket new things are sort of breach reporting, as we all know, and accountability. And I think the accountability and obviously the penalties and regulatory powers that have been provided to the regulators have we've seen probably a big culture shift, but that didn't happen just on the 25th of May. That was happening in all the organisations. So, I mean, I moved to PaySafe this time last year. Ahead of that, I was in Barclays, and in all the organisations that I've been in, and from colleagues who are in other organisations. I think the main focus was on ensuring that people were ready and that they were prepared for May the 25th. And I think the big thing was a culture shift in support from the chief executives level, so board level, coming down throughout the organisation. And I think that's been a real a positive. I mean, there's been a huge discussion about GDPR and about the changes that have come into effect, and that's really opened debate. I think so people who maybe traditionally hadn't been thinking about privacy or data protection in their workspace were, because they're seeing changes coming through themselves as consumers, are now thinking more about how GDPR and data protection laws have an effect on the work that they're doing, because it goes all the way through most businesses, through HR and finance and delivery of products and services. So I think it's been like a positive change on the whole, and I think accountability was the real game changer for me, particularly figuring out kind of where all your data is held, and understanding that decisions that people make in terms of how personal data is collected and processed now need to be recorded, and any kind of risks need to be properly accepted at executive level. And that's been a positive from. For me, kind of making my job a little bit easier, right? So, but for consumers, I think it's been a real boon. I think just putting aside my sort of being supportive of marketing and CRM colleagues' hat and putting my consumer hat on. I think I enjoyed watching in May lots of emails coming in from companies that I hadn't heard from for about 5 years, asking me that I'd once bought a thing from on the internet. They'd say, do you still want to hear from us? And just ignoring those, like that was sort of fun from my perspective. So if you'd been doing your marketing consent, or you'd been collecting your marketing consents correctly in the first place, then then there's probably no requirement to send out one of those remarketing emails, right? And I think from a commercial perspective, those organisations that have gone through that exercise, I heard earlier someone talking about seeing an 80% reduction in the subscription base for a newsletter. I mean, that's a massive drop, isn't it? And that's going to take years for that organisation to get back to that level. So, I mean, that's probably one of the horror stories coming out of GDPR, right? And I suppose, what else have we seen that's changed? So, I mean, there's a lot of companies selling GDPR compliance products and services, and I think there's been a bit of project fear with GDPR. I don't think the regulators are going to go from zero to hero and slap a 4% fine on anyone, on May the 26th.
Hopefully not.
And they'll continue to be, as they've always have. I mean, certainly in the UK, the ICO has always been an educational regulator, and looking at sort of coaching organisations towards compliance. And but that said, that sort of project fear, I think there's a lot of misinformation out there now, which kind of makes life a little bit more difficult, because you have people coming already with preconceived ideas about what they want, and you say, well, actually, hang on, you don't need to do that. That's not a thing. Yeah. And that's not just internally from a commercial perspective, but from a consumer perspective. I mean, particularly, we've seen a massive hike in right to be forgotten requests, and I think that's a misunderstanding from data subjects who maybe see that as an absolute right when it's in fact a qualified right, and that's been interesting, and we're still not quite sure why.
Yeah, we have been actually discussing before the panel with Jindřich about some misconceptions of the consumers actually, or of the customers about about GDPR and what it means to them. So maybe if I can ask Jindřich now for his views about the general things that have happened with respect to GDPR from his perspective.
Since I've been involved in many implementations projects, being an attorney, before 25th of May, I've seen so many projects with harsh schedules, tight schedules, in order to show off some external compliance. Because what I really see in the companies, in many of them, also in many of those companies I've been involved with, is that they've divided the compliance into separate groups. The external one that is visible, and that's something what we need to have in line, and then the internal compliance. There will be some time for that after 25th. And what I can see, not in the companies I'm taking care of right now as a DPO, but in many of those I have some records with, is that they've somehow lost the momentum. And from that harsh schedule project, now it's that I'm like swimming in the swamp and trying to find the way out, how to take time to make, let's say, HR procedure work and comply with GDPR, how to do the stuff like marketing, etc., etc., etc. So I think that the most crucial point right now for many of the players in the market is not to lose the momentum and move forward, and let's say find out that, or get acquainted with the situation that from the project perspective, now GDPR becomes line management or a line process that needs to be managed time after time, and so on. And from the outside point of view, from the customer's point of view, I, as a DPO, have that experience that many people totally misunderstood the issues of the GDPR, and that they find or try to use the GDPR as a hammer or some sort of tool to get into the doors that should be already opened. from my perspective, from, let's say, my experience with Saska, we have so many requirements from the customers who are at the same time the data subjects, which are titled or labeled GDPR request, but the content has nothing to do with the GDPR. It's like, I've registered my internet gaming account and now it's lost. What has happened? What have you done with my data? And simply speaking, regarding Czech regulation or complying with Czech regulation, is that, well, you haven't met the requirements of Czech Gaming Act. So we needed, or we had to remove your account. But that has nothing to do with your subject data. So I think that in many cases, the people, as Simon already said, feel that now they are in certain bubble of or cocoon, which has a lot of absolute rights that needs to be fulfilled by the data controllers. But I think that is time on the side of data controls to, let's say, it's going to be a lengthy process, long-lasting process, tedious process, but you need to educate your customers that not everything they've read in the internet is actually valid assumption regarding GDPR. And that's what's need to happen right now, I think. That's my perspective after 25th of May.
Sure. Thanks very much. Now, Ellen, I know that you're not a sort of GDPR is not your bread and butter, but still you know the gambling market quite well. So what have your observations been?
Yeah, I suppose not as someone who's here as a subject matter expert, but as someone who's worked in the industry. I suppose the potential impacts of GDPR for operators are probably as significant as some of the regulatory implications that have been discussed in some of the other sessions. I think you know, there's been comparisons comparing, I suppose, GDPR to Y2K, and I suppose the similarity, I suppose, was that on the 25th of May, the world didn't end. But I think after that, that's where the comparison stops, because it's only in the years and months ahead that the real impact of GDPR on operators is going to be felt. And I think if you look at betting companies and operators, I suppose one of the key significant assets of all operators is customers and customer data. And that is, I suppose, squarely within what GDPR is looking to I suppose, impose more regulation and restrictions on. And I think what certainly we've been surprised on in terms of advising operators and also other companies in the sector is, I suppose, that whilst the 25th of May came and went, many operators are still, I think, still in the process of finishing their compliance projects. And that goes from, I suppose, recording where you know, what records they have, to what processing they have, to still getting DPAs in place, which is, I suppose, now that we're in a compliance mode, is a significant issue for operators. I think when you look then at particular issues that can affect, I suppose, say, valuations for companies, particularly some of the issues that I think I would see of interest and surprise, I suppose, with GDPR is, I suppose, the level of reconsent emails and notifications that you saw going out, say, prior to the 25th of May. And I'm not quite sure, I suppose, when you look at some of the notifications that have gone out, is it, you know, a lack of understanding of what was required by GDPR? Because, you know, prior to GDPR coming in, e-privacy law, a lot of operators would already had opt-out requirements in their marketing, so GDPR didn't change their implications. So I suppose by sending out reconsent emails to your entire database, you run the significant risk of not getting consents back from a significant portion of your database, which is one of your key critical assets. I think the other area I think that will be interesting to see how things tease out, I suppose, is just around the area of data portability. One of the key, I suppose, differentials for operators is what they do with customer data. And I suppose that really is the secret sauce in terms of you know, how you analyze in terms of from a risk perspective, but also in terms of your offerings and your incentives. And that really is a differentiator for operators in terms of the sophistication and the investment that they've put into those analytical tools. And I suppose if you take the area of data portability, I suppose Article 20 of GDPR, I suppose, entitles people to look for their data to be transferred, and I suppose to other sponsors. So under Article 20, what it looks at is, I suppose, the information that the customer has provided to you. But I suppose the area I think that will be of concern for operators is around how Article 29 of the working group has looked at that, where they have a broader interpretation, and I suppose it also looks to cover, I suppose, you know, what's been observed in relation to a customer. So if you think about it from an operator's perspective, if you get a customer looking to transfer their information, including, say, what analytical processes have been applied to their information to a competitor, I suppose you are in a way looking at giving away the secret sauce for a lot of operators. So I think it's important, I suppose, there. I think, you know, we've been doing a lot of work where we're looking at that right only applies in certain circumstances where you're relying on consent. And then I suppose it's really looking at the other criteria why you might have be holding information, ensuring that that it's clear in your consent notifications, like areas like legitimate interests, so that then you don't get caught, I suppose, as operators by having to actually transfer over you know, your secret sauce in a way in terms of your analytical tools. And I think finally the last point, I suppose, that again is only in the years ahead. You know, betting and gaming, I suppose, is an international operation. You know, you go from operators that are based in offshore jurisdictions like Gibraltar, but their big markets are going to be either in Europe, with Brexit coming along, US opening up. That opens up, I suppose, a whole new area of complexity in relation to the transfer of data. So that is an area I think that's going to cause huge headaches for people that have to deal with this on a day-to-day basis.
Thank you, Alan. And I think there'll be probably more headaches to come, because you mentioned this e-privacy regulation, and for those who don't know, that's basically a subset legislation that's meant to deal with personal data and privacy in these, let's say, electronic communications, or to put in a more simple words, online. And of course, originally the e-privacy was meant to be effective on the 25th of May together with GDPR, but it got stuck in the legislation process. And it does contain a little bit, a number of differences. For example, it does not contain legitimate interest at the moment as one of the sort of legal titles to processing of data. So obviously we may be somehow finished with GDPR and its implementation, but we might be here, or not here, but at this conference again next year, and talking about what the e-privacy means and how our company is dealing with that. But before we get there, actually, Sean, what are the views from the US market about this, you know, funny GDPR European thing, and how do you see that?
Well, it is amazing the amount of emails that came out, you know, around in May. It was just staggering. But you know, from a U.S. perspective and a U.S. law firm perspective, from a viewpoint of representing clients and licensing in various jurisdictions, a lot of clients, you know, now that gaming is so international, you have clients that there may be EU citizens that may be part of a client group. So one of my clients is a large slot manufacturer, and right after what they did, after GDPR went into effect, is they sent a letter out to all the law firms, and they were asking about what sort of information do you normally get from individuals who have to get licensed in the company? Is it the type of information where you're going to be sharing it with regulators by email? And so what they're starting to do, the gaming companies in the States are starting to sort of, track this so that they have some idea, so they can, so that you don't have a misstep. The troubling thing with that is at least I think about it, and Alan's next to it, he's Irish, and the Irish have very liberal citizenship laws. So if you have a grandparent who was born in Ireland, you can actually get an Irish passport. So there probably are lots of people that you would never identify who live in the United States, who've never been to Europe, who may have the dual citizenship, and then all of a sudden you have someone who's a client of yours, and you're transporting their information in a way that you're not supposed to in violation of GDPR. So from a law firm perspective, we've started to put in some procedures to sort of try to track those things. And I think with the law firms tracking it and with the gaming companies also tracking it, that's really what we're starting to see. Now the tricky thing, not to scare the US-based lawyers on this, but it's a legal ethics aspect, is that there actually is in the model rules in the ABA in every state, you have a duty to safely protect and safeguard your client's information. So what if you don't follow the procedures and you inadvertently send somebody's personal information out to somebody, and that party makes a complaint? In theory, they can make a bar complaint and go after your license, saying, "Oh, look, they weren't following what they needed to do." So that's the scary aspect. Now, the one part that's kind of interesting, and I don't know how GDPR would actually deal with this, but if you regularly deal with, like I regularly deal with the Nevada Gaming Control Board and the Mississippi Gaming Commission, the Colorado Division of Gaming, a lot of information about license applicants is sent by email. And the question is would GDPR actually reach out to the state agencies as they're emailing internally among themselves? I'm thinking about the concept of, say you have someone who's a European national who's going through licensing and is having a licensing problem in Nevada or somewhere, and that person gets turned down. And what happens if that's the case? Then he or she could invoke the GDPR and say, "Hey, I filed this application in New Jersey or Nevada," and they were sharing information. They were making conclusions about my suitability based upon my personal data, and my personal data was actually shared within their email systems. Now, I'm pretty sure the Nevada Gaming Control Board would take the position that that's a privileged, not an open record, so there'd be no way to find it. But you can see how this is a real slippery slope. So you can see from the states, even though this is, an EU aspect, there are things that we have to do as lawyers and just with the gaming companies to sort of comply with this as best we can.
Yeah, thank you. And actually, the sharing of the data is one of the sort of key issues and key troubles that I think many companies and operating are trying to deal with. And I can think immediately of two main sort of areas of data sharing, and one is exactly what you mentioned. Somehow is the sharing based on your sort of legal requirements, typically KYC, AML. There's also lots of sort of data sharing in the area of marketing, and now what somehow I found very interesting with respect to privacy and GDPR application in the area of gambling is how the regulations are sort of playing together, because of course gambling is a highly regulated area. There's lots of money exchange, and financial services is also a highly regulated area. And then comes the privacy regulations, and of course these regulations are not always neatly streamlined, and the regulators do not often sort of talk to each other. So, and I presume in the UK, and Simon may know better, but the Gambling Commission issued a GDPR guideline effectively saying, well, operators, don't you think you'll get away with your sort of gambling regulatory obligations, that you will find an excuse in the GDPR. So how do you, and anyone on the panel, how do you see these, how do you see this issue of clash of regulations?
So, Yeah, I mean, it's a good question, right? So, I mean, particularly, I mean, if I take them sort of, one at a time, say, information sharing or data sharing and exchange between operators and financial services institutions, as well as, law enforcement agencies, that's really well established in the UK. We've got clear, included in the we had it in the Data Protection Act 1998. It's been literally lifted and dropped into the 2018 Data Protection Act, which incorporates the GDPR. And it basically requires, if you want to share information for anti-money laundering or financial crime prevention purposes, to carry out a two-stage test, one of which is necessity. So is it necessary for us to share this information to prevent crime? And then the second part of that is whether the sharing of that information, or the failure to share that information, I should say, would be likely to prejudice the prevention, detection of crime or the apprehension, prosecution of offenders. And so, and that's fine. That's a reasonably well-established threshold test. It sort of flows right the way down from Article 8.2 of the European Convention on Human Rights, and it's a well thought through and worded bit of legislation. But the real change, obviously, since May has been the fact that that organisations now need to demonstrate and have a recorded decision-making process of how they've reached that decision. So almost like a harm test sort of thing that will show you that you've either got to the threshold or got over it and are lawfully able to share that information. So I think they sit quite comfortably, together, the GDPR and the anti-money laundering regulations from that perspective. But coming on to the marketing side of things, so that again is an interesting thing, and particularly with the e-privacy directive that we currently have. I think what I see has changed there is that people have looked at the consent mechanism for use of cookies and similar technologies, and they've applied a GDPR level of consent. So, and that basically means that the individuals have to have made a clear and informed choice, and crucially, I think, have the ability to opt out. That is as easy as it is to opt in, right? So, and that, I think, is where you'll see probably people may have noticed since the 25th of May that on a lot of websites there are now much clearer cookies notices and like sort of wizards that will enable you to make your choices and set your choices, and that, I think, so I was sort of trying to research how much of a drop that's been. I don't know how reliable the figures are, but one website that I looked at suggests that there's been almost a 25% drop in the use of third-party cookies, and I think that's demonstrative, A, of consumers' dislike of that sort of tracking technology, and B, organisations starting to get to grips with how those bits of legislation sort of join up.
Mm-hmm. Okay. Anyone else has views on this?
Well, from my perspective, when it comes to specific regulation for the gaming industry, since it's not very, it's quite new, from 2016. I think it's quite well streamlined with the GDPR requirements. The practical issues that arise from this regulation, like the registration process, the registries as such, they don't make that much, there are not that much issues arising from these. But the issue comes to the administrative practice. And then in many cases, many public authorities and bodies, including also the topmost offices of state, are in certain cases, trying to ease their work up by requesting more information they need to have, or then they are capable to have or gain from the regulation. And there comes the very practical issue: what's more? Is it GDPR and privacy, and therefrom potential issue and potential risk of being fined for non-collaboration and non-compliance with the specific regulation, or is it to comply with GDPR and prohibit or refrain from providing the information with some sort of link to the GDPR? And I have to say that from my perspective and my practical experience, more or less almost all of the clients thereafter go to the situation then we rather suspend the privacy in order to comply with the with the requirement of the state bodies. And that brings me back to what Simon already said. Also, the officers of state need to get to certain level of precaution regarding the privacy. And I think that will be even longer time than when the most compliance projects for major clients will be terminated and finished.
Yeah, I agree with that. Well, I'm just surprised looking at my watch that I'm already going to be told off by Jamie, whom I promised to catch up on the on the schedule. So I'm going to open the floor to questions. Does anyone have any burning GDPR or privacy-related questions on our esteemed panelist? Really? Oh, there's one there. Yep. Anyone wants to?
Yeah, that's a good point, and that's something that I think is not really clear, because you're right. If the information gets transferred from Europe to the United States, for example, and then basically that information is then shared on the United States side, would the GDPR apply? We actually think that it probably would, because the premise behind it is to protect the European nationals. So if you could sort of do a bypass by just doing this international transfer, I don't think that sort of is an easy way to thwart what the GDPR is meant to do, which is to have protection for European nationals worldwide.
And please keep in mind that when it comes to international transfers, the GDPR is quite strict and explicit in its requirements regarding the international transfers. At first, it's the more strict information policy you need to provide your clients and European nationals with. The first thing, the more practical issue, which can be quite annoying, is preparing the DPIA, Data Protection Impact Assessment, which in many cases of international data transfers is thereafter required, and you need to have it present when the regulator comes to check out your compliance. And also the issue is that this particular case, or the international transfers, also needs to be proved to be legitimate. And I think that many regulators around Europe will see with a lot of dislike if they have that feeling that by transferring the data outside of EU, you are trying to get out or reach certain level of precaution from their powers. So I would be very, very restricted when it comes to international data transfers.
Also, one area that's also kind of intriguing me personally, and the debate has gone a bit silent about how we actually enforce GDPR outside the EU. It's these, what the EU is going to do actually about someone who's then storing and collecting data and doesn't have a substantial sort of base or assets in the EU, whatever. Any further questions? Did I see a hand up anywhere? Well, if not, I think, Jamie, we really need to finish now, right? We should have 10 minutes ago. So, well, thanks so much, Simon, Indrich, Ellen, and Sean for attending the panel. Thank you, audience. Hope you found it interesting, and I hope to see you around at this conference in the beautiful city of Prague. Thank you.
Thanks, Wojciech, for that panel. I think GDPR is something which is affecting more than the Europeans, and from what Sean just said, it's affecting me because I'm a British national, which makes me particularly concerned. Anyway, we are running over time. I'd ask you all to be back at 4:20. We really want to make sure we catch the buses. Thank you. Thanks again for the panel.